Like many questions surrounding Social Security disability benefits, answering the questions of how marriage or divorce can affect your benefits begins with, it depends. And it depends on which disability program you're applying for or have qualified for. Many aspects of winning Social Security disability benefits are confusing and hard to understand. That's where we can help. We regularly produce fresh video content to help you untangle the ever-changing Social Security disability process. To stay in the know, hit the subscribe button. There are two disability programs: Social Security Disability Insurance, which is known as SSDI, and Supplemental Security Income, commonly referred to as SSI. SSDI pays benefits to you and certain members of your family if you are disabled, if you have worked long enough and recently enough, and if you have paid Social Security taxes. SSI is not based on your work record. It is based on financial need. The income of a spouse has no effect on SSDI benefits if you are filing for disability under your work record. This holds true no matter how much your spouse earns or whether he or she is receiving disability benefits. However, SSI regulations are different because this is a program for people with very limited or no income or assets. Your family earnings and assets can affect your benefits. Once you get married and if your spouse is not eligible for SSI, Social Security will count some or all of your new spouse's income as well. Social Security may reduce your monthly payment or maybe even completely stop your benefits if your combined income is over the allowable amount. Social Security will also look at the amount of your combined assets after you are married. To be eligible for SSI, your assets must be less than $2,000 for an individual or less than $3,000 for a married couple. If you have qualified for SSDI and you get divorced, your ex-spouse may be entitled to benefits based on your Social Security earnings record, even if your impairment occurs after the divorce. Different from spousal support or alimony, these benefits are called divorced spouse benefits. Your ex-spouse can receive up to 50% of your whole monthly disability benefit. However, your ex-spouse receiving divorce benefits does not reduce the monthly benefit amount you receive. To collect benefits, you and your ex-spouse must meet certain requirements. You and your spouse must have been married for at least 10 years. Your ex must be at least 62 years old. He or she cannot have remarried unless they remarry after 60 or 50 if they are disabled, and they cannot be eligible for a higher benefit on their own record. Termination of an earlier marriage will not affect eligibility for this benefit. Because SSI is a needs-based program with strict limits on income and countable assets, an individual's benefits may increase or decrease after a divorce depending on the division of property and alimony payments. If you are unable to work due to a disabling impairment and are considering applying for disability benefits or have been turned down for the disability benefits you believe you have rightfully earned, you should consult with an experienced disability law firm. Call or email us at Cuddigan Law to arrange a free consultation about your situation.